Swayed by Article 48 of the Constitution, which grants all parties access to justice. And in light of that, the family, in its quest for justice, for statements that are being relied on in the investigation that will be resulting in the recommendations that the DPP would make. I'm swayed by Article 48 of the Constitution, which grants parties access to justice. And the family is seeking for justice at this point, in knowledge and in view of the investigations and the recommendation that will be made by the DPP. And that will be humbly submitting on our application to be granted the statements that have been written by all parties.
The alleged events, the subject of the current miscellaneous application before court, happened. It is the landlord's submission that he is suffering loss of rent income on account of the fact that he is not receiving rent since the events before court started. To date, the arrears stand at the sum of Kenya shillings 269,500. And having keenly listened to the able investigating officer, it was his submission that there is no decision yet to be made by the DPP. And in his quest, he made an application seeking for the closure of the miscellaneous file. I didn't get him to indicate whether he is still carrying on any investigations. It is our humble request then that Your Honor directs that the IO yields vacant possession of the premises, which specifically is apartment number 3, Block D, Preston Court, Kileleshwa, to the landlord, so that he does not continue to suffer loss of income. Apartment number 3, Your Honor, Block D, Preston Court, Kileleshwa. Preston Court P, yes. Given the admission by the IO that they have completed investigations, as far as the miscellaneous application before you is concerned, they yield access to the landlord. That is all, Your Honor.
Council can be guided by the relevant law to file an application before court for the lease of that property to the landlord. It does not form part of the application made by court by the state.
The investigation officer says we have not
it is the
that is why this file is relevant. Please go, Council.
Application for the court to grant us orders, specific orders, and those orders are contained in paragraph 8. And there is a danger that if the court opens itself to global issues, although touching on what happened in that house, they will not be subject to this application, and the court will be descending into the arena of investigations itself, which is not a role envisioned by the Constitution, but judiciary descending into the role of investigations. Your Honor, we pray that the court be guided by paragraph 8 of that application that is before you, in which the state specifically prayed that the court grant the orders and for the state to be allowed to investigate the respondent. And once those investigations are complete, as per paragraph 8, Roman 9, the IO indicated he will forward the file upon completion of investigations to the DPP for the use of analysis. That has happened, Your Honor. And that is why we are before you asking the court close that application. We are not releasing anyone. What the DPP is doing is that this limb of the investigation has been completed. It is not a conclusion of the investigations. The DPP needs to peruse that file. The rights of the victim will be protected, as well as the rights of the respondent. And we will not wish to infringe on anyone's rights at this moment. None of those issues which are enumerated in paragraph 8 have been touched by my senior as having not been conducted. The IO has said he has concluded investigations. Documents to the council is unheard in law for the reason that the right to information does not include the right of everyone getting an investigation file to peruse before the DPP has made a decision to charge. The Constitution provides for when parties will be handed documents and statements. And it is once we have an accused person in court who will have those documents handed to them to prepare for trial if there is an accused person. Supervise the DPP and other agencies to confirm that they are indeed performing their duties as provided for under the Constitution. If the family will feel that the decision of the DPP is not a correct decision, they can move the High Court. But as decision has not been made yet, Your Honor, and we did not come before you, Your Honor, on an inquest as to how a death occurred. We came before you specifically guided by paragraph 8 of our application. And that is why the court granted the orders it did. It did not depart from that paragraph. It was guided by that paragraph. The IO indicates he has obtained all he has. And he sought under that application. We are just praying that we be allowed to close this application and to allow the DPP time to go over the investigation file and make a decision on what should happen to those investigations. That's all.
With your kind permission,
mentioned to this court. But let me start by saying, Your Honor, there are clearly two parties that have a very keen interest in the outcome of these investigations. And those two parties are the family of the deceased person, and we do not trivialize matters pertaining to loss of life. But the second person who has a monumental interest in the outcome of these investigations is none other than my client, who is currently bailed in this matter. And that is why she has continued to offer full cooperation with the investigative authorities. Your Honor, my learned friend has talked of my client as if she's a flight risk. She has nothing to flee from whatsoever. She has not been charged, accused, or in any way put on the spotlight, save for the fact that she's a witness to the circumstances under which the deceased met his death. So would strongly object to use of terms like murder by a senior advocate like Mr. Omari when a matter is under investigation and is pending before the DPP. Use the word murder.
Your Honor, I want to be protected. I have not referred anybody to be the murderer.
No, he used...
I have only put it very clearly that there is somebody dead.
I didn't interrupt him. I showed him the courtesy. He used the word murder, not murderer. There's a difference in the dictionary if he checks.
Okay.
He used the word murder, not murderer. He used the word murder. Murder implies someone caused the death of another. Willfully. Whoever that person is. We are today in court with no such evidence. So I'm using the word murder and I'm objecting to the use of such language. PC Kibei has said he's investigated the matter. The DPP is yet to make a decision. As Mr. Omari himself said, as the prosecutor said, let us wait for that decision to be made. As I told the court, my client is ready to continue availing herself to assist with any requirements of the DPP, any requirements of the IO, any requirements of any court that may become seized of this matter in future, if required. What we object to is preemptive strikes. Preemptive strikes by parties who, yes, we understand are grieving. They are grieving. Your Honor, as is my client. As is my client. She lived in the same property with the deceased. So this is not a one-way street, Your Honor. And let us protect the independence. And that is my final point. The independence of this investigation is critical. I have gagged my client, Your Honor, since December 12th from media inquiries for interviews on this matter. Gagged her from talking to anybody apart from the IO on this matter. Gagged her from responding to social media. In the meantime, what has been happening? We see media interviews casting all sorts of imputations against her. How frustrating must it be for her to have to keep quiet and listen to all these statements and judgments going on about her and not to talk? And why is she not talking? To preserve the independence of the investigation being carried out by the lawful authorities. We don't have their statements. We don't have their reports. And she's the respondent to this miscellaneous application. What will anybody else do with the DPP's statements or his reports until the DPP says, this is the direction I wish to travel? The rest of us must maintain silence and respect for the independence of that investigation. That's all we can do. And patiently. And let me assure my learned friend, nobody has a deeper interest in the speedy conclusion of this matter than my client, so that she can at least walk out and voice her side of the events that took place, whatever direction the DPP takes. But as of now, she's maintaining absolute silence and allowing them to do their job. Whether they do it in a miscellaneous file or they do it in the DPP's office, Your Honor, this investigation is ongoing. It will not stop until they get to the bottom of how the deceased met his death. And we look forward to that being sooner rather than later. But let's not be policed, supervised, threatened, intimidated, or otherwise coerced by any party. Any party, no matter how aggrieved they may feel, they should allow the law and the legal process to take its course. That's all I wish to state.
Your Honor, I would like to add something by my senior here. None such information has been tendered by the state. Thank have faith in the system and in the DPP to make the right decision. With that in mind, and pursuant to the application made by Counsel Kihara for information pursuant to access for justice, this is our concern. As has been demonstrated, there has been a narrative that has been pushed by the family. And this narrative has not been based on any information. It was based on hearsay, and that is even the subject of the current. If it does impede the rule of law, it is our contention that any information that they are applying for to obtain now, prior to the DPP making his final conclusion, is not only premature, but is likely to be misused and abused. Lastly, as the court is pronouncing itself on the issues that have been raised, I would still restate on the role of any other party outside the respondent and the applicant in a miscellaneous application to be clearly addressed. Everything that my senior, Mr. Omari, has stated here is so prejudicial and which will be printed in the media and is not based on an iota of evidence.
I don't know.
I would like to
just a minute. I don't know whether he's Mr. Omari as an advocate or as a family advocate. Because the position I'm pushing across is the family that is mourning. It is the family. It's not Omari. Omari, I have nothing personal in this matter. Neither do I have any personal interest in the respondent. All I'm saying, let the voice of the deceased's family be heard.
Therefore, we need to use these terminologies very sparingly. We have a respondent here. We have an applicant. We do not have a victim. We have a deceased. And we would like all those issues to be addressed, because the information coming out from the court and also from the bench is what is now coming to prejudice the respondent here. That is all.
Issues have come up upon submissions by all the parties, and the court will need time to make a ruling on the same. So you can take a date for ruling. So we can do this on 15th. I think next week the court will not be sitting. We are attending a magistrate's colloquium.
15th of February?
So I propose, the week of 15th, 15th of
Wednesday, 15th February is fine. Your Honor, since the... it's a ruling date.
Your Honor, I think in the preliminary...